Okay, I think we'll go ahead and get started here. My name is Mark Mayer. On behalf of ACR-Chicago, I want to welcome everybody to this evening's program, Challenges to Confidentiality in Online Mediations, Practical Considerations and Agreements. I want to thank all of you for joining us tonight and hope that it is useful to you. Just a little bit of business before we get started. ACR-Chicago is an umbrella type of organization for mediators, arbitrators, and other people involved in dispute resolution. We invite all of you to become more involved with the organization, either in programming, to do programs or make suggestions, and other things that we do, and also perhaps get involved with our board. If you're interested in doing any of this, you can contact us via info@acrchicago.org. Also want to note a couple upcoming programs that we have. On March 18th at 5:30, we have Keeping the Peace During Times of Racial, Political, Cultural, and Social Strife. And on April 13th at 5:30, we will have a panel discussion on Zoom mediations. Today, we're kind of focusing on confidentiality. That program in April will cover a lot more issues than simply confidentiality. You can go to the acrchicago.org website to register for those programs. So I think only registration is open for the March program at this point. Tonight I will be speaking, and then also Teresa Frisbie. Teresa is the Director of Dispute Resolution Program at Loyola University Law School here in Chicago. She has been arbitrating and mediating for a long time. In 2018, ACR-Chicago named her the Mediator of the Year. She's recognized as a top professional in various dispute resolution fields by her peers and by her students. So tonight we're talking about confidentiality somewhat in general, and then also as to issues as it relates to online mediation. This can be a somewhat complex issue. We're just trying to give you some things to think about, to be aware of, and to consider. We are not necessarily having any answers or clear-cut solutions to all of this. We are just trying to make you aware of things that might be out there so that when you're doing mediations, you can take those things into account. Confidentiality is considered a cornerstone of mediation because it enables the parties to openly discuss their case without adverse consequences. Hopefully it contributes to a feeling of safety and being comfortable, which engenders the process and helps people come up with new ideas and new approaches and ways to reach resolution. Confidentiality in another way also plays a role in impartiality for the mediator. Impartiality is another cornerstone of mediation. If a mediator always had to be concerned about anything that he said would then be disclosed and, let's say, litigated in open court, it could very easily curtail mediators' actions and involvement in the process. With confidentiality, they can be assured that anything that they are saying or suggesting hopefully is staying within the room, and that also contributes to the successfulness of any resolution or getting the parties to move from their positions and maybe towards resolution. First of all, generally confidentiality is addressed through mediation agreements. Most people, when they do a mediation, they have a written agreement or for certain set forth various parameters either before the mediation or at the start of the mediation regarding confidentiality. Basically, the agreement will provide in various terms that anything that is discussed or comes up in the course of the mediation stays there. It is not to be disclosed by any of the parties or the mediator, and this hopefully contributes to the success of the mediation. So it's important that it should be at least discussed, and it is helpful to have written agreements. Arguably, with a written agreement, if there is an attack on the confidentiality or an attempt to undermine it or disclose certain things that are considered confidential, the agreement is a contract, and it can try to be enforced to keep everything confidential as the parties agreed. This needs to be done prior to the mediation, and it also should be reinforced during the course of the mediation, surely in the beginning of the process. Also, with online mediation, a lot of times people are now taking breaks because it gets a little hard to stay on the screen for long periods of time, hour, 2 hours, that sort of thing can be difficult. And perhaps it wouldn't be a bad idea to just mention that again when people come back together. And we will talk about that with some of the practical matters that we're going to be addressing here. Confidentiality is also protected by operation of law and by statute. Many states, or actually most states, provide confidentiality for mediation proceedings, though the degree of protection varies by state. A lot of states have adopted the Uniform Mediation Act, which recognizes a qualified mediation privilege. The Act does set out various exceptions, and this is clear in the Illinois version of the Act, where there are various exceptions. I think a lot of us are familiar with those, but this would include criminal behavior, abuse, threats, and that sort of thing. The other thing to keep in mind with confidentiality is if a certain piece of information or a document would be available in a regular court proceeding, the fact that it is raised or mentioned in the mediation does not protect it from disclosure in the court proceeding. It cannot be used as a shield for discovery in litigation. So that covers just general principles. Later on, Teresa Frisbie will discuss the Uniform Mediation Act a little bit more. These are just general principles that we have talked about with respect to mediation in general. However, now that with the COVID circumstance and the pandemic, most mediations are being done via Zoom or other online platforms. This raises additional issues that we should all be aware of with the confidentiality. With online mediation, there is a greater likelihood that you are going to be dealing with participants in different states, different jurisdictions, even different countries for that matter. Though this contributes to the process and hopefully the success of the process, it also raises issues because not all jurisdictions take the same view of confidentiality in their jurisdiction. And if you have your participants from various jurisdictions, there may be various interpretations of how that confidentiality is handled. And that's why I think it's important to at least have a written agreement. Additionally, with this technology, there are other what I consider risks to confidentiality besides the interpretation by courts. Different things come up that we will discuss in more detail, but with these online platforms, you have issues of other people in the room, people breaking into the mediation, people participating in a mediation in public spaces because that's where they are available at the time and they are speaking, and perhaps there are other people in the area that are hearing everything. There may be someone who's on a public bus somewhere participating in a mediation, and it's being broadcast to everybody there. You should be aware of that, and it's something that does need to be addressed. I just want to diverge slightly. One of the handouts was a case entitled Cormier versus Chote. I included that in the handout materials because from a legal perspective, it provides some good background information on mediation confidentiality and the mediation privilege. I think it's an extremely well-written document. The Association of Attorney Mediators filed that document. It's in the Northern District of Illinois. And I think it sets out some interesting things. There was a mediation that did not end up in settlement. There was a later settlement. And then the plaintiff sued her attorneys because she then was not happy with that settlement and wanted details of the mediation to be, or she didn't want to, the attorneys that she was suing wanted details of that mediation to be disclosed. That has been briefed, but even though it happened some time ago, there has been no ruling on that. I am now going to talk a little bit about more with what I consider practical considerations, or let me diverge. Teresa, do you want to talk about the Uniform Mediation Act just briefly at this point?
Well, as you said, I think this group's pretty familiar with the exceptions. I mean,
okay.
If we,
okay, we'll just leave it at that. That's fine.
Okay.
That's fine. So now we're going to go to what I consider a little bit more of the practical considerations. And the thing with confidentiality, if the proceeding is somehow being broadcast or other people are part of it who have not signed any agreements or anything, that is a way that people can undermine the confidentiality and argue that the proceeding was not confidential because all sorts of people had access to it. Other people heard what was going on in there. And if other people heard what was going on, then how is it confidential and why should it be confidential? Before we were doing online mediation, as we are now on Zoom and other platforms, everybody kind of came to a location, they came to a room or an office, and the mediator had some control over things as far as what people would be doing in that room. You didn't have to worry about other people being in the room because you knew who was in the room with you, the door was closed, and that's all there was involved with it. Now I will talk about the potential problems with recording. And even in a closed room, there was a potential problem with recording because someone could have a recording device in a briefcase, a purse, or something else, and could have been recording the proceeding, though at times that would have been addressed in the agreement or mentioned by the mediator. But sometimes people would be doing that, and then that could create a problem. With online mediation, I think that is a bigger concern. Via Zoom, there is a recording feature. Generally, the mediations are not recorded and the mediator would have the control over that. So as far as the actual Zoom platform or other online platform, arguably the mediator has control of that. However, it does not prevent somebody from having a camera in the room that would not necessarily be visible, or another audio recording device that would not be apparent to people, and could use that to record what was going on. They can give explanations that I want to remember what happened and what was discussed. I want to go back and think about things. But if we're claiming confidentiality in the proceeding and there is an agreement in place, I believe that any type of recording device undermines any confidentiality, and people should be aware of that. And the mediator should mention that to the participants, that there is no recording allowed either by camera or audio device or other means. And as I said, this should be reinforced in the agreement and also in oral statements at the beginning of the mediation by the mediator. And also if there are any breaks when people come back and everything, just to remind people that this should not be allowed and it should not happen. If people raise issues on that, I would encourage you to discuss it and explain to them why it's important not to do that and how important confidentiality is to the process. Now, the next issue is with privacy, and I have alluded to this somewhat. The online platforms are very nice for a lot of reasons. They're convenient for people because people don't have to travel to someone's office. They don't have to go to a business district. They don't have to travel out somewhere. People don't have to necessarily travel from out of state or anything else. They can arguably do it in the comfort of their home. And this is a good thing, because a lot of times if people are in their home or another place where they are comfortable, this can also facilitate the mediation, because they may not be on edge. They might not have their flight or fight mechanism activated or anything, because they are in a setting that they are comfortable, and that will make them more comfortable in the mediation. And hopefully this would contribute to the success of the mediation. However, the comfort of one's home also raises issues. There are probably other people that are in that home, children, spouses, friends, and other people, family members. So I think it needs to be reinforced with the participants that even though they are at home, that we are hoping that they are in effect, what we will describe as a private setting, that there will be no interruptions, that nobody else can hear what's going on in the course of the mediation. This is also true that people do have this, even if they're not at home, but they're in what I will describe as a public space. There are other people in the area. This can both interrupt the mediation and also, I believe, threaten confidentiality. And so I think even though we like that people are comfortable where they're at, that this needs to be brought to their attention. I'm seeing a few comments in the chat. If you wish, feel free to break in and make comments or raise issues. We are doing this somewhat as a discussion, and I think the numbers will be manageable if anybody does wish to jump in and make any comments on this. The other issue, or another issue that I am putting under the heading of privacy, is what I'm calling unauthorized persons present, either explicitly or hidden. For example, if there is a family dispute or a domestic relations dispute, sometimes a participant's, what I will call new partner or new friend, wishes to be part of the proceeding, or that person wishes that person to be there, both for support and for comfort. And I think it's important that we know who is in the room and who is participating. And if those people are allowed, then it's okay. But these people cannot simply be there, either hidden from view or otherwise. People can put up backgrounds, people can sit off screen. And this, I believe, would also threaten confidentiality if these people are in the room. Sometimes they are making comments, sometimes they are passing notes, and it's just not part of the process the way that we set this up. They should be either part of it or not part of it. If they are part of it, it must be by everybody's agreement, the mediator and all of the parties. Also, and this kind of goes to the public spaces, sometimes people have to be at work when they're participating in a mediation, or they're doing, they're in a school, babysitting, homeschooling, remote learning. These can be problems, they can be distractions to the mediation itself, and then also raises issues with the confidentiality. Also, as the mediator or the facilitator of the mediation, We should be aware of who has the meeting ID and password if it's a Zoom or these other platforms have other ways of getting in. Be aware of who has access to that information so that unauthorized persons don't suddenly show up, causing both confidentiality problems and just disrupting the process. The next topic in this area that I would like to address is what I am calling inadvertent disclosure of private communications. Especially in Zoom, and that's what I'm addressing generally because it seems to be a more popular or a popular platform. We have chats, we have breakout rooms, waiting rooms. The chat can be done specifically to another participant, but if you simply pull up the chat and put something in there, it gets broadcast to everybody. So for example, if an individual wants to chat with his attorney about something that's going on, if they do it in the general chat function, everybody's going to see that and obviously raises confidentiality problems between, for example, in this case, the lawyer and his client, but it also can cause problems with the mediator, with parties, especially if, for example, a party is using the chat function to contact the mediator and whatever he is saying or she is saying or doing then gets broadcast to everybody that's part of that. Also, sometimes during the course of the mediation, if it is a time when people are in caucus, someone may want to talk to someone, they get on the phone and without realizing that audio is being broadcast to everybody. So that is something to be aware of because I believe if that is broadcast, then there are potentially confidentiality issues on that. The other thing, one of the last areas that I'm going to be covering is the sharing of information and documents, both before and after the mediation, especially with non-participants. If these things are being shared with other people, I don't know if there is a viable claim of confidentiality, if all sorts of other people have access to that information, and so that people should be aware of that. Lastly, sometimes when people are getting to the point where they're making decisions or an agreement is getting close, they say that they want to discuss the matter with other people. Sometimes they want to just take a break right there and do it. Any of those things, I think people should be aware that it should only be done with everybody's agreement that that is being done. Because otherwise, arguably, there is confidential things that are being discussed with non-participants, which also raises the issue of whether you are maintaining the confidentiality as you are hoping to do so. And as I started to say, confidentiality is very important to mediation, and that's why I think all of these things we need to keep in mind. If anybody has any comments or observations at this point, I would welcome you to chime in. Thank you. Someone did raise a question as to whether a non-consensual recording of mediation would violate Illinois law. I do believe it would. I am just suggesting that at least flagging that issue to people, both in the agreement and at the start of the mediation, will at least put them on notice that this is not appropriate and should not be done. And I think that also addresses Ms. Bell's comment that you can't necessarily stop people. We are just trying to let them know that this is not the way that we want to run this. So. Thank you. If you wish, Teresa, I think maybe you can start at this point.
Okay, thanks. Can everybody hear me?
I can, yes.
Okay. All right, well, first thing I want to say is it's really nice to see all of you. The last in-person event I went to before the pandemic had us all hiding away was the International Mediation Competition at Loyola. And I want to thank you all. So many of you came and judged, and I really appreciate that. So as Mark mentioned, we're hoping to generate a discussion here as we have a lot of expertise gathered in this group. I'm going to start out talking about the Law 360 article that I was part of. I don't know if everybody's seen it, but I got into this article project because Loyola was looking for projects that our law students could do that were substantive over the summer because there were fewer opportunities because of the pandemic. And Jeff Kitchaven, who's a very talented mediator and good guy, somebody I've presented with before, reached out to me to see if we had a law student who could help research confidentiality. It's a topic that's interested him in a long time. And now that we're all mediating online, it seemed like a good time to take a closer look at this topic of confidentiality in mediation. And really, it's a problem that's been around a long time. And the problem is that a court in another state whose laws do not protect confidentiality might let someone discover what was said in mediation in a state with laws that do protect mediation confidentiality. This issue of lack of predictability in how courts treat mediation privilege and confidentiality, which I consider separate, and I think everybody that's familiar with the UMA understands that, it's a long-standing problem. Their law review articles go back many years. Ellen Deason's written about this. Joseph Lips wrote a good article, but lawyers aren't paying attention really to the complexity of the law of mediation privilege and confidentiality. So again, with people participating in mediations now from maybe all over the country in an online mediation, it's a more pressing problem that we need to think about. And of course, when you're mediating on Zoom, it's more difficult to say where the mediation actually takes place. If only some of the participants in your mediation in state one are in state one, the courts of state two are going to have even greater discretion to disregard the laws of state one. In the article, we wrote that the idea that online mediations, or any mediations really, are confidential is a myth. I would clarify and say that saying that mediations are fully confidential without any exceptions is a myth. And this is because conflict of laws principles allow courts to disregard mediation privilege statutes and confidentiality agreements. So the first case that we talked about in the article is Larson versus Larson. That was a 10th Circuit case. It was a sibling battle over family assets. The lawsuit was in Wyoming. They had previously mediated in Colorado, and that was a face-to-face mediation. Their mediation agreement said, all communications, whether oral or written, made in the course of the mediation process are confidential by this agreement and the Colorado Dispute Resolution Act. Also, at the end of the mediation, they signed a document called Basic Terms of Settlement. But then, as so often happens, they could not agree on final documentation. So there they were fighting again. In the Wyoming litigation, two of them moved to enforce this term sheet. And what they were seeking was a PowerPoint that the other sibling had used at the mediation in Colorado. The magistrate judge allowed discovery and admission of the PowerPoint. And the 10th Circuit took a look at this under an abuse of discretion standard and found there was a true conflict of laws. Colorado privileges these documents while Wyoming expressly allows discovery of confidential mediation communications when a party seeks judicial enforcement of a purported mediated settlement agreement. And then of course there was their mediation agreement. The 10th Circuit was not persuaded that Colorado law or that agreement should govern. And the court wrote, although Wyoming's choice of law rules state that the law of the state chosen by the parties to govern their contractual rights and duties will apply, this general rule was overridden by the longstanding principle that Wyoming courts will not apply another jurisdiction's law when it is contrary to the law, public policy, or general interests of Wyoming's citizens. So the 10th Circuit concluded the magistrate did not err in allowing discovery of the PowerPoint presentation. So we were kind of surprised by that result. You may think, well, is that just a rare outlier? You know, I'm not really worried about some court in Wyoming getting involved in any mediations I do. And maybe not, right? There's kind of a low chance of that happening if you're mediating in Illinois. But you might worry about it more if the question involved whether your parties could end up in litigation in New York. And so we did look at New York law and found case law. And this was really Tyler Codina, one of our law students. He was just great on this project. And we found that New York courts use a similar choice of law analysis to compel disclosure of material that was seemingly privileged, but with the accountant-client privilege under the laws of another state. And this case is People of the State of New York versus Price Waterhouse Coopers. In that case, the Attorney General was seeking to compel Exxon and Price Waterhouse Coopers to comply with a subpoena to Price Waterhouse Coopers in connection with, this was the New York's climate change suit against Exxon. And the appellate court, the appellate division affirmed an order granting a petition to compel production of documents. While Price Waterhouse Coopers and Exxon contended that the communications between them took place in Texas, and Texas protects those communications from discovery under the accountant-client privilege. New York does not have that privilege. And they argued that under the balancing test of the second restatement of conflicts of laws, Texas privilege law should apply to protect those documents from discovery. The appellate division applied New York law, finding we reject Exxon's argument that an interest balancing analysis is required to decide which state's choice of law should govern evidentiary privilege. Our current case law requires that when we are deciding privilege issues, we apply the law of the place where the evidence will be introduced at trial or the place where the discovery proceeding is located. So it wasn't really all that clear from what we looked at that really was New York's current case law. About a year before, a district court judge in the Southern District of Ohio had summarized the state of New York law on this issue. This is the Wilmington Trust case that cited in the article. And that court said that under New York's choice of law principles, the governing law is that of the jurisdiction which, because of its relationship or contact with the occurrence or the parties, has the greatest concern with the specific issue raised in the litigation. So New York courts apply an interest balancing test to determine which state has the greatest interest in applying its law. In cases requiring a choice of privilege law, the interest analysis usually has led New York courts to apply the law of the jurisdiction in which the assertedly privileged communications were made. So our argument is that since some New York courts are willing to disregard another state's accountant-client privilege, does that mean they were also going to disregard another state's mediation privilege? And we found a case that arguably points in that direction. This was a divorce case. And in that case, it's the Hauseiger versus Hauseiger case. The mediator, Carl Vall, served as the mediator at the mediation. And after the mediation, one party subpoenaed him to produce records and testify. And that was in a proceeding to determine whether the terms of their separation agreement were fair and reasonable at the time of making the agreement. And the mediator moved to quash the subpoena on the grounds, among others, that these people had signed a confidentiality agreement. And the trial court refused to quash that subpoena, and the appellate division affirmed, notwithstanding this confidentiality agreement. And so that actually got appealed up to the New York Court of Appeals, which issued a memorandum opinion affirming the appellate division. And the Court of Appeals conveniently noted that these people had waived whatever confidentiality that had been part of their mediation. So then the mediator was required to produce documents and to testify. So this kind of highlights this issue, even though there was a different basis at the highest court for this ruling, it does highlight that at least the appellate division seems a little insensitive to mediation confidentiality. We also looked a little bit to see if things were better in federal court, and beyond the minimal protections of Rule 408 of the Federal Rules of Evidence, there's not really a federal mediation privilege. It's, from what I'm reading, it's one of the most uncertain areas of mediation law is the existence of a federal mediation privilege. There's cases both ways. And there isn't really much of a settlement privilege in federal law. So there's a Sixth Circuit case, the Goodyear Tire case, that adopted a federal common law settlement privilege. But other courts have rejected that decision. We cite a Federal Circuit case and a Northern District of California case. The U.S. Court of Appeals for the Federal Circuit stated that a settlement privilege does not outweigh the public interest in the search for truth. And the court wrote, while there's clearly an important public interest in favoring the compromise and settlement of disputes, disputes are routinely settled without the benefit of a settlement privilege. It is thus clear that an across-the-board recognition of a broad settlement negotiation privilege is not necessary to achieve settlement. Something we did not talk about in the article is the Alternative Dispute Resolution Act of 1998. This is the law that directed district courts to adopt local rules providing for confidentiality and mediation. There are lots of such rules. It's kind of a hodgepodge, but this adds another layer of complexity and unpredictability to this whole area. So the article that we wrote concludes that it is easier to ask a New York court to use the evidence law of a more protective state to keep your mediation confidential if the assertedly privileged communications were made in that other state. But when you mediate online with participants in different states, it's harder to show where their mediation communications were made, of course. So, and even if one mediation participant was in New York or another less protective state, and even if the court applies a balancing test, the chances are a New York court will order disclosure, or at least the chances increase that a New York court will order disclosure. So our overall conclusion in the article is, be careful about assuring mediation participants that any mediation is confidential, and be careful with mediation agreements that promise that the law of a particular state that protects mediation confidentiality will apply, because you can't guarantee it. Okay, so that's the Law 360 article. So what is the best way forward? And I think this is really good for all of us to discuss. So Jeff Kitchafen and I presented at the ABA tech meeting on this article, and we differ a little on what all this means. He's written some other articles. I think one of them is one of the handouts tonight. He argues that giving people confidentiality agreements could be mediator or attorney malpractice. He also argues that confidentiality doesn't really matter because there's no empirical evidence that confidentiality causes disputes to settle. And I'm not sure that I agree with those conclusions. So I'll just give you some of my thoughts and questions about using confidentiality agreements that's kind of come out of this project. I really think we need to balance mediator worries about liability against protecting parties and the mediation process through confidentiality and mediation. It also seems to me maybe this issue is just a matter of lawyers and mediators being more forthcoming in confidentiality agreements about all the exceptions to confidentiality. And perhaps we need to explicitly point out that an additional exception to confidentiality is the risk that a court in another jurisdiction will apply conflicts of laws rules and ignore your mediation confidentiality agreement and or your state mediation statute. Because as mediators, do we just stay silent and avoid ever giving parties agreements to mediate with confidentiality provisions? I mean, at least practicing here in Illinois, we know under the Uniform Mediation Act, this is the confidentiality part's left to contract. And the lawyers are not paying much attention to this issue. You know, they never negotiate these agreements to mediate. The parties and lawyers also, they have an expectation of confidentiality. We have decades of mediation practice in our country, and everybody's acting as if mediation is privileged and confidential. You know, so it's a long industry practice, and we have institutions, courts, mediators getting parties to sign confidentiality agreements. It's such a norm that courts have confidentiality forms. And somebody talking about they have a mediation coming up, you know, a friend of theirs might say, yeah, it's confidential because they went through it. So that's a concern. So I don't feel comfortable ignoring this and just hoping the lawyers get it right, because what kind of mediator am I if I just don't worry about privilege or confidentiality? I mean, isn't this an assumption the parties have about the service I'm providing? So one thought I had is if the mediator is not going to put a confidentiality provision in the agreement, maybe we need a way to push the lawyers to do it. You know, we bring it up in the pre-mediation conference and get a commitment, you know, who's going to draft it. What else can we do to protect the mediator but help the parties? Something else, well, again, if we treated this as just another exception to privilege and confidentiality and spelled it out in the agreement, something long and detailed, that might address it. I thought about, could we ask parties to agree to a seat of mediation, you know, as you do in an international commercial arbitration? Well, those two processes are really quite different. And if you look at the Singapore Convention on Mediation, that's fairly recent, the language in that reflects the fact that there is no seat in international mediation. So I don't know if that's a helpful thought. And then there's the issue of, does mediation confidentiality even matter, right? So Jeff's arguing doesn't matter. And I think that confidentiality does matter. And I admit I'm not aware of good empirical evidence that supports that, you know, cases are more likely to settle if there's confidentiality. But judges, legislatures, scholars have long accepted that confidentiality is one of the most crucial elements in the mediation process. Ellen Deason wrote an article in 2006 addressing the need for confidentiality. She explores the value of confidentiality in mediation, and she, using that term as privilege too, using a cross-disciplinary approach. So she looked at different fields and explored the concept of trust. And in her article, she made an interesting point. She said, a judge or legislature that is weighing disclosure against confidentiality is often faced with a concrete situation in which the advantages of disclosure are apparent. The need for confidentiality is abstract and vague. And I think that that's really true. So she concluded that trust is what makes mediation function well, and you need confidentiality in order to build trust. I'd also like to share my own personal professional experience. One example comes to mind. This was a mediation involving, it was a construction defect case, and it was two men. One was the builder, he built a mansion for the other guy. And the builder was older and very experienced, and the purchaser of the home was young and quite wealthy. So I, of course, am looking for what their real concerns were. And one of them says to me in caucus, I just don't want to feel like I've been taken. So I got permission to share this with the other side. I said I had a feeling that I thought it could make all the difference and get the case resolved. And I said this because I had just heard the exact same phrase in the other room. So he agreed I could share it. I went in the other room and I shared it. the fact that they were both worried about feeling like they were being taken, one by somebody who's older and more experienced, one by somebody who had a whole lot more money, the case just about immediately settled. And I really felt like that vulnerability, that, taking a risk to say something like that, I don't know that they would have done that without confidentiality. And my last point is that I served on the ABA task force that looked at the studies to see what works in mediation. It's a hard thing to study. There's so many variables. So yes, there's no solid empirical evidence, but a lot of human experience that we open up to people when we think our confidences will be kept, and that opening up helps settle disputes. So I'd really love to hear your input, everyone else, what you think about these ideas. And if we have time, I could put up a in the chat. I can put up the JAMS confidentiality provision to see if we could play around with it. But let's hear from other people.
Now, my recollection of the Uniform Mediation Act is that it gives the mediator a privilege too. So in the New York case, where it went to the Court of Appeals, their highest court, as I understand your description of it, the court seemed to take the party's waiver as a waiver of any privilege the mediator might have. So arguably you have a better position as a mediator here, where the Uniform Mediation Act is part of our law, then the parties simply can't waive it.
Yeah, I think that's right.
We got to get the Uniform Mediation Act passed in more states. That's something that could be done.
Yeah. Other thoughts? I mean, this has been discussed at the Association of Attorney Mediators, and I know everybody was kind of like, oh, well, I'm not going to be using confidentiality agreements anymore. And I don't know that that was the right reaction.
Yeah, as far as that goes, we're talking about this and we're just trying to make people aware that it's out there. But I do believe there is general agreement that people feel the actual risk of this is relatively low, that it usually doesn't come up. And if it comes up at all, it is in commercial cases and not necessarily in other circumstances. So obviously it can come up in family disputes also.
And I'd be curious to know how people think that attorneys being present in the mediation impacts the desire to use the information from the mediation in the litigation. Because I think the attorneys hearing things exacerbates the desire to carry the information forward when the case doesn't work, which is one of the reasons I prefer to have the attorneys behind the scenes. And I know that I'm an old fogey in that regard, but that's how I like to do it.
I think, go ahead.
No, I think that's a good point. If you read all these cases, they're only about mediations that don't settle. And the challenge of confidentiality is brought up in the subsequent litigation or the continuing litigation. Teresa, there's a couple of cases since your article out of New York, actually, that deal with a different nuance to this. Is there's a case called Intelligent, which distinguished between private mediations and court-annexed mediations. And in New York, there's protection to court-annexed mediations. And Intelligent, they were trying to say was a private mediation, so the confidentiality of the court protection didn't apply. The most recent one is analyzing Intelligent, called Accent Delight, which is a December 2020 case, where they upheld the confidentiality and said that there was nothing different between the two. Intelligent talked about a goofy analysis that said three kind of considerations. One, ultimate resulting unfairness to one party if the disclosure is not made. It's not available anywhere else. The evidence is not available anywhere else. or some kind of special need for that in the litigation. And so it's quite an interesting case. The accent delight case is a case that's gone on for I think a decade, multiple appeals. It involves a very valuable piece of art. And lucky for the lawyers, everybody involved has lots of money. And so they keep litigating it and have there's about 6 accent delight cases. The one you want to read, if you want to read about it, is the district court decision from December of 2020.
Well, thanks for bringing that up. You know, and I do think that, you know, it wasn't like we were arguing, you know, here's the definitive law on this. I think we were showing like, hey, there's some goofy stuff that happens, and are we disclosing it enough to people or being careful enough? I mean, even just looking at all the exceptions that we have under the Uniform Mediation Act, I don't get the feeling that the lawyers are talking to the parties about all those exceptions, right?
So somebody asked for the site. So what I'll do is I have a folder with the cases in it. I'm going to give you a link, a Dropbox link, so you can access these 3 or 4 files. And there's a couple of other decisions in there as well. So
Thanks, Tom.
if I'm not paying attention, I'm distracted by trying to do that.
Thank you.
Turn my camera off so it doesn't look like I'm not paying attention.
What kind of a mood would it set in a mediation for the mediator to come in and say, well, generally it's confidential, but this, that, this other circumstances, you know, all of a sudden you're turning it into a legal proceeding, you know, instead of a conversation.
Yeah, I mean, a lot of mediators say, or is otherwise required by law. That does cover a lot of stuff. But I understand what you're saying. You're trying to get people to have a conversation and to feel comfortable.
Another approach is if you're drafting a contract for confidentiality is just like we can do in arbitration, we can select the law under which confidentiality will be applied. It doesn't matter where it's seated. And I think if you choose California law, there's some pretty solid cases, and I think Rojas is in that folder as well, that would give you the strongest argument to protect the mediation process.
The other thing is, I think if you reinforce that the mediator is going to keep everything confidential and all of the parties have agreed to keep it confidential, hopefully that will set the appropriate tone going forward, but obviously there's no guarantee.
The other thing I think is worth keeping in mind is that forgetting about the process, cybersecurity is a big part of this, that are we sure the documents that are given to us are safe in whatever file or folder or platform we're using. And so to make sure that our repository for documents can't be accessed by somebody. And so confidential documents are separate confidentiality from the confidentiality of the process.
Yeah, that's a great point.
Yeah.
Well, we have about 3 minutes left. Any other thoughts on?
Yeah, Colette raised a question is, I guess, once there's a potential problem with the confidentiality, either with the privacy or other people coming in, should we end the mediation? I think it would be appropriate to address the issue with the parties, emphasize the importance of the confidentiality, and ask the parties if they still wish to continue at that point. I don't know if anybody else has any other suggestions or comments on that.
I think Colette's specific question was about, for example, if someone has to consult with an insurance carrier or something like that, if I recall reading back in the chats. And if that's the question about if someone else needs to be consulted, I don't think that's a problem, because most confidentiality agreements make an exception for people like accountants, lawyers, and you can put in insurers that need to be consulted.
Additionally, I think if it's disclosed, it helps. Let's just put it that way.
So what happens if, so you're on a mediation, you've, done all, everything you're supposed to do, you asked the parties to please, not have people come in and out, but that's still happening. They're disregarding all the confidentiality. So as a mediator, at that point, do you say, well, but you're not acting in good faith. I think we should end the mediation.
I certainly wouldn't use the good faith word, but I would say it sounds like this is not a good time for the mediation to continue, sounds like you're distracted or something, so that you can have a private conversation with them to ask why that's happening and whether they want to continue or not. Right? They may not be aware that someone's walking behind them through the room. I mean, we've had all kinds of weird things on Zoom. So rather than just sort of blame them by using a word like good faith, I would just be transparent about your concern and that you want the mediation to be effective. So you want to ask them, do they want to reschedule? I wouldn't let it just go by.
Thank you.
Mhm.
Okay, well, it looks like we're at 6:30, Mark. My takeaway is that this group's not concerned about these issues of, confidentiality not mattering anymore, or the, mediator liability, but that, maybe we can craft better agreements to mediate that might be helpful.
And I also think when you're online, just to be aware of these other issues that are going on with, private space, recording and everything else, just so that we don't run into problems with those things.
Yeah. I actually want to make a comment here. Is it urgent?
Sure.
Oh, you can walk in the background. Teresa, I'll add a note here. You've shaken me up here, and suggested that the area of law is more complex than I wanted to realize. I don't even actually want to know that, because I know that if I get my parties engaged in a pre-mediation negotiation over a confidentiality term, I'm killing my mediation before it begins. You get lawyers billing on exceptions to confidentiality mediation, and you get parties coming into a mediation not candid. And one of the things I want to have going for me is that everybody's signing an NDA, including interpreters, Zoom operators, everybody in the room is signing one. But it looks airtight, but don't look under the covers and don't read the articles about all the exceptions. Just everybody go forward assuming that's the case. But in answer to your comment, looks like nobody's concerned. I'm very concerned. The mess in the law is problematic for me.
Yeah, and I mean, right now you don't hear from the lawyers. They aren't negotiating those terms. They sign the thing and send it back, and you get going. But I definitely empathize with what you're saying. That would be a nightmare.
I think the word is transparency about the problem with the clients and the lawyers so that we can figure out what we want to do. I mean, to ignore it is a problem. To talk about it among ourselves the way we're doing and to figure out.
Oh, forget it. I can't hear you. Not sure.
People do, but it's scary.
I don't think it's as big of a problem for mediators as it is for the litigants. They're trying to get discovery from the other parties, not necessarily from us, because we can destroy our file. But if there's a pending piece of litigation, the attorneys can't destroy their file. So their mediation settlement agreements, their notes from mediation, might be in there. And so in terms of us, our risk is that we're named, but in the cases I've read, the mediators aren't named. They're not subpoenaed. There's a process initiated lawyer to lawyer to get documents from that session or a number of sessions. Like that PowerPoint you were talking about, Teresa.
Yeah.
Very, very complex.
Okay, we're past our end time.
Okay, and on Tom's comments, which I think were very appropriate to this, and especially with us as being mediators, we will now close the session. I want to thank everybody for joining us and participating. And we look forward to having you join us in future programs. And you can always go to the ACR-Chicago.org website for things that we're doing. And there is the March program that we welcome everybody to join. Thank you very much.